Check, check, check.
Good evening. Before we get started, since we're a smaller group today, I'm requesting everybody to shift one row ahead just so that conversation can be easier. Perfect. Good evening. On behalf of Thai Dubai, I take great pride in welcoming you to our event today. Our session today promises to be highly insightful as we listen in on this conversation between our panel of experts as they share their insights on the new law and how they impact your business. Allow me to briefly introduce you to TIE and its core values. TIE is an organization that fosters entrepreneurship globally. What started as a conversation, a small gathering in Silicon Valley in 1992, has now turned into more than 60 chapters in 14 countries. Our main pillars are mentoring, networking, education, funding, and incubation. While TIE has a global reach, we make sure each chapter gets to focus on the local ecosystem. We run exceptional programs for entrepreneurs in the MENA region. Our Time Mentorship Program is an extremely beneficial program for companies who are looking for support from seasoned and successful entrepreneurs who can help navigate their startup journey better. Our Thai University program, which I am pleased to share with you, that has officially launched for 2023 and we're now open to applications from student entrepreneurs across the MENA region. This program not only grants access to one-on-one mentoring, investor connects, and networking opportunities, but also a chance to pitch your dream business at the Thai University Global Pitch Competition in Silicon Valley. Thai Women Program, over the past few months, we have conducted multiple events, 5 regional pitch competitions, and 1 MENA pitch competition at GITEX earlier this year to help our women entrepreneurs get exposure, all whilst training them, guiding them, and mentoring them as they prep to go on to the Thai Women Global Finals at the Thai Global Summit later this year for a chance to win $100,000 and more. The Middle East chapter of Thai Dubai, is based in Dubai Internet City for over 20 years. The easiest way to be a part of our community and to stay updated about our upcoming events and programs is to follow us at Thai Dubai across all social media platforms. It is great to see some familiar and new faces. A very special thank you to our charter members of Thai Dubai and our board members for their continued support and dedication towards the chapter across the MENA region. Please feel free to connect with any of us if you'd like to know more about Thai Dubai. Without taking any further time, I'm honored to introduce our speakers for the day. Chatura Randenia. Chatura is a partner in the dispute resolution practice of Afridi and Angel. He is experienced in both institutional and ad hoc arbitrations, seated in civil and common law jurisdictions. And in addition to representing clients in arbitration, he also sits as an arbitrator. In litigation, Chatura works with local advocates on matters before the UAE federal courts, including the Federal Supreme Court in matters of national security. Chatura regularly acts for clients in high-value disputes in construction, maritime and shipping, banking and employment, as well as in complex disputes relating to commercial transactions. Most of his work has a strong cross-border element. He is a regular speaker at workshops and conferences on dispute resolution in the UAE and is a regular contributor to publications on arbitration and dispute resolution as well. Chatura is recommended and ranked as a practitioner in dispute resolution in Chambers Global and Legal 500 EMEA. Is recognized as a leading practitioner in the MENA region by Asian Legal Business and of course is our very own Thai Dubai charter member. Lalatendu Mohanty, LM is the EVP and Head Trade and Working Capital at RACBank. He joined RACBank in January 2009 and leads the Business Expat Lending Division. He holds over 19 years of banking experience in lending to SMEs and brings a unique perspective in his understandings of SME business. Sunil Chacko is the Senior Vice President and Head of Collection and Remedial at RACBank. He manages collections and recovery for business and wholesale banking with expertise in multi-segments of retail and business banking products, remedial management, risk charge management, and portfolio management. He holds over 20 plus years of accomplished experience across the banking and financial sectors. Chatura, the stage is now finally yours.
Thank you very much, and good evening. Thanks for being here. I don't know whether this is required or, anyway, I'll use this. Just for your information, it's still a goalless draw. So the important things out of the way. You're going to put the thing up? Okay. So since there's a major sporting event going on, let me start with a sporting kind of angle to this. Unfortunately, I don't have anything football related, so I'll use cricket. So imagine you're the captain of your team, and you're getting ready for an important match, and you've packed your side with fast bowlers. You turn up on match day, and you find that the pitch is a dust bowl, say subcontinent. It also turns out you're the captain of the home team. All of a sudden, all your plans have gone to waste, and your chances of winning are pretty low. Second anecdote. I'm sure you would have watched legal dramas, Suits. Hands, if anybody has seen it, there you go. I'm here to tell you that real law practice is nothing like it. But I think it's interesting. It's interesting because I don't get a dull day at the office. Because, especially in disputes, my first job is to understand what my client's business is. If I don't have that information, there's no way I can win. I'm incentivized to learn about my client's business because A, I'm being paid to do so, and 2, I want to win. Now, imagine there's a third party who has no financial incentive to learn what you do and does not care what the outcome is. And that person is your judge. What do you think that's going to do to your case? So those are just two illustrations to show you how important a dispute resolution clause is. And yet, they are frequently what we call a midnight clause when it comes to contract negotiation. The people go all out to discuss and agree the commercial terms, but the dispute resolution clause is usually a boilerplate from a standard contract that was drafted sometime in the 90s. And that's going to cause you a lot of problems just for the reasons that I outlined previously. So let it go. That's fine. The key takeaway I would like you to take away from this is that you have a choice. You have a choice of where you want to go if in case there's a dispute between you and your counterparty, and what rules will apply. In Dubai is fairly unique that way because we have more forums to choose from. You get the Dubai courts, which is the default sort of provision. Then you have the DIFC courts, which is an English language common law court which operates in Dubai, and you have the equivalent in ADGM. And then you have arbitration. So what I'm here to do is to try and convince you the next time that you are entering into a contract, either with your suppliers or with your counterparties for something a little bit more significant, give some careful consideration as to where you want a dispute to go. After all, you've negotiated a hard contract. It has value to you, and that's why you entered into a contract in the first place. When things go wrong, you want to be in the right place to hear your dispute, and you want the right people to hear your dispute. So let me just, here we go. So this is, great, I've managed to finish where I've just started. So there's the onshore courts where you go by default. Certain things you have no choice but to go there. Commercial agencies cases, labor cases, of course criminal cases all go to the onshore courts. You can choose arbitration, and you can choose the rules of arbitration you want to be bound by. It can be the ICC rules, it can be the DIAC rules, it can be something specific to the industry that you are in. A couple of things that you need to bear in mind. It has to be entered into by way of a written agreement and signed, physically signed by or entered into by people who have specific authority to enter into arbitration agreements. You have to determine the language, the number of arbitrators, and so on. One of the big reasons that the arbitration scene in Dubai is so vibrant is because the local courts are so bad. Also, the local courts are all in Arabic. Most of the people here, business people here, are not necessarily conversant in Arabic. And, if something matters to you, you want to know what's going on. You need to at least understand what's going on, so you can choose the language. More recently, you came up with the DIFC courts. Now, my own theory is that the DIFC courts came around because the rulers, in their wisdom, quite rightly, felt that people are unwilling to risk investment in the UAE unless you have a good, robust system of dispute resolution. And rather than try and fix what's onshore, they created something completely new. The judges, when we started out, were all mostly English common law judges. We had judges from Singapore, Malaysia, Australia, and now you have Emirati judges who have been trained in common law and you come up. So again, in English language, again, it's accessible. So what's the best forum for you? It really depends on your requirements. If it's a low-value, simple matter, you can try your chance with the local courts because they are by far the cheapest alternative that you have. You can get certain remedies like travel bans against your defaulter, as it may be, and attachment accounts far more easily. Arbitration is good for complex or specialized disputes. And that's because you can choose your arbitrator who doesn't have to be a judge. If you're in the tech space and you need somebody who understands the tech space in order to sort of figure out who is right and who is wrong, you can go to arbitration. And in the arbitration clause itself, you can say, we will agree that X or Y or Z is going to be our arbitrator, or a person who at least has 5 years of experience in this industry. It's all about the agreement of the parties. There are two main advantages of arbitration as well. One is that it travels extremely well internationally. There's a convention called the New York Convention on the Recognition of Foreign Arbitral Awards. There's, I think, almost 200 signatories to it, maybe more. Recently, Iraq became a party to it. And what that means is so the UAE is party to it. So that means if I have an award in the UAE, I can pick up that award and go and enforce it directly in 199 other countries. And that's a great advantage if you're dealing with international companies. I've acted on many occasions where I've got an award here and I've had it enforced in New York or London or anywhere else in the world. So that's a key advantage. The other one is, of course, it's confidential. You don't want to necessarily air your dirty laundry in public. So under law, arbitration is maintained strictly confidential. So you make sure that your problems remain out of the public domain. The DIFC court is quick, it's efficient. You get a whole range of remedies that you don't get from other places. For example, think of it as an English court. The DIFC court is, of all these three things, is the only court that will give you a worldwide freezing order, which means that if somebody owes you money, you can attach their funds wherever it is in the world. Outcomes are predictable because it's a common law system, which means that the onshore Dubai or UAE is a civil law system where there's no binding precedent, which means every case is decided on its own merits, nothing more. Common law is a system where you look at the previous cases that have happened, and if the facts are similar, the same outcome will be achieved, which means, of course, it's a lot more predictable. And you can get your costs back. Provisional remedies is something that you should be aware of. I'm not going to spend too much time here. It's something, what are the options available to you before you go into litigation? Can you prevent people from traveling? Can you attach their bank accounts so to make sure that they don't get rid of their assets by the time you finish your judgment? Can you get orders to preserve evidence? The answer to those will really depend on where you have chosen as your dispute resolution forum to be. So the DIFC has possibly the most broad range, and the local courts probably have the most narrow range. So again, depending on your dispute, you can always foresee. You know who you're getting into bed with in terms of business. You know what your problems are likely to be. You know where they're likely to have parked their assets. So you take those into consideration, and you choose the right place for you. So this, what you see on screen, is a very quick summary of how proceedings work in Dubai courts. Everything is done on the basis of written documents. There's no oral advocacy. Cases used to take years. Now it's much faster. There are 2 levels of appeal as of right. One of the key things that you need to bear in mind is, at least in civil disputes in the onshore courts, the courts appoint experts. And I use that word expert in the loosest possible sense. They're not really experts. And the problem is 99% of the time, the court will follow what the expert says, because under the law, if the court agrees with the expert, they don't have to give reasons as to why they agree. But if they disagree with the expert, they need to give reasons. So courts, like most humans, follow the path of least resistance. So if I agree with them, I don't need to give reasons. And unfortunately, there is a huge range of both competence and integrity when it comes to local courts. So it really, the experts of the local courts. So there's a lot left to chance over there. In arbitration, it really depends on the rules that you use. A few things that set aside arbitration is you can actually call in witnesses, you can ask for document production, although both of these things from next year are going to be available in the onshore courts as well, although how it's going to be implemented is a different matter. You can have oral hearings. There's actually oral arguments where you get to stand up, or your lawyers get to stand up and argue your case, where you as a witness can be heard, or you can ask your other side to come up and be cross-examined. Awards are supposed to be given in 6 months. You can extend it for a couple of times. There used to be a case where awards used to take 3-4 years, but that rarely happens now unless it's a particularly complicated case. Here's the million-dollar question. You got your judgment, how do you get your money? Because I can get you a judgment, you can put it up on your wall, great, and sometimes that's an important part of litigation. It's vindication, to be told that you were right and the other side was wrong, but mostly it's really about the money. You have to file an execution case, the other side gets served summons, you have to wait for 15 days, and if they don't pay within the 15 days, you can start attaching their assets. And that's where really it's going to hurt. In arbitration, it used to be the case that you needed to go through all three tiers, but of court of first instance, court of appeal, court of cassation, that's no longer the case. The UAE enacted a new federal arbitration law, which makes the process much faster. You can go straight to the court of appeal and get your judgment. This is, again, something that I'd like to draw your attention to. Litigation funding. Litigation funding is where a specialized company essentially buys your claim from you. It's slightly different from, say, insurance, where they buy the claim outright. Here, it's not, perhaps I misspoke. They essentially fund your litigation in return for a share of the proceeds. So there's no prohibition against it in UAE law. The DIFC court actually makes provision for it. The ADGM courts have a very detailed set of rules, possibly the most detailed, certainly the most detailed in the Middle East, perhaps outside of the UK and the US, the most detailed there as well. The new DIAC arbitration rule makes provision for them. So these are professional companies with large investors who look into claims, do their assessment as to how good or bad the claim is, and if they think it's a good claim, and if they think there's a good prospect of recovery, they'll say, we'll take the risk. We'll fund you, either 100% or some agreed percentage, and in return, you will give us a share of the winnings. I think there was a study done a couple of years ago as to how much money is left on the table because companies don't want to pursue litigation, and you can't blame them. Litigation is an intensive exercise. It takes up a lot of management time that can actually be used towards productive thing, and it's also a drain on your resources. So if you have somebody coming in and saying, look, listen, we'll foot the bill for you, you give us 50% of whatever that comes through, or whatever such percentage is. And that's a great way to manage your cash flow and your risk, but it's also a great way to send a message to the other side. If you go to the other side saying, look, here's a third party who's confident enough in my claim to fund me for it, what do you think your chances of winning are? Most likely it'll lead to a settlement. In most cases, what I do, and this is my mantra, is that a bad settlement is often better than a good judgment. Because settlement means, A, you're more likely to have preserved the relationship. 2, it means you've spent less time. It means you spent less money. And you got into a place where you're happy with. And choosing the right forum is very good. For example, in the onshore courts, you don't get your costs back. You only get 2,000 dirhams regardless of how much you actually spent your lawyers and whether you even won outright or not. In the DIFC, you do get your costs back if you win. And also if you lose, you may have to end up paying the other side. So you've got to be very careful about asserting a claim. In the Dubai courts, it's quite easy to just, assert a claim. Yeah, let's see what happens. What's the worst that could happen? I'll just pay my lawyer, 50,000 dirhams or whatever it is. In the DIFC courts, there are real cost consequences. And there's a mechanism called a Part 20 offer. Let's say I'm suing you for 1 million dirhams. You come back to me, you make a Part 20 offer and say, I'll give you 800,000 to settle. Now, then, if I don't accept it, I have to take that, and I go to court, I go to trial, and I get the million, then that's fine. But say I made only 500,000. The court said you're only due 500,000. I may have won the case, but I may end up paying the other side's costs because they made a reasonable offer, which I couldn't beat in trial, and therefore I made him unnecessarily waste his costs, and therefore I should be made to pay for it. So you can see how different the game is depending on which forum you are in. So that just concludes the section that I had on dispute resolution. If you remember what today's the label on the tin said, dispute resolution with a focus on dishonored checks. So I'm going to stop here, and I'm going to let my esteemed colleagues here pipe in with any comments that they have, and perhaps we can take any questions that you had about what we just discussed right now before we move into the other one, because it's a slightly separate topic. Thank you.
Hi, good evening.
You can. Go ahead.
I'll not take much time. I'll just give you a background as to why we're here. And I really wanted to connect in the sense that...
Consequential damages, how are the different, like the local code, arbitration, and I mean, how do they see it?
So consequential damages is really a question of law, not forum. So again, that's a good point. So the position for consequential damages under UAE law is different from, say, English law. So let's say you enter into a contract saying, because of the position on consequential losses, consequential losses is a little bit easier under, say, English law than UAE law. UAE law is very, very stringent. And there's also no concept of punitive damages under UAE law, because it's a Sharia concept to say that harm cannot be made good by more harm. So that's why there's no concept of punitive damages. So you might say, well, I like the English law position better. And you put it into your contract. But your dispute resolution forum is the Dubai courts. The Dubai courts are supposed to recognize that English law provision, but they will not in practice. So that's out. But if you go to arbitration, they will apply English law. If you go to DIFC courts, they will apply English law. Consequential losses, the general test is, UAE law provides for it, provided that it is a natural, it's a natural consequence and a foreseeable consequence of the act of harm. There is a distinction that is drawn between something that has been done inadvertently and something that has been done intentionally. Where if it had been done intentionally, then you could even ask for loss of profits. Now, that's the law. In practice, very, very difficult to show causation. The UAE is not really what you'd call a damages-friendly jurisdiction. They take a very simplistic approach. And in my experience at least, the courts confine them to the actual provable claim, losses suffered. So consequential losses, the evidentiary burden is a little bit too difficult. In theory, it's claimable. On certain rare occasions, you do get it, including loss of profit, but generally it's an uphill task.
Okay. Then in your slide, you mentioned that if you go back to the slides, like the second or the third slide.
Tell me when to stop. So this brings me to the other thing.
Yeah, the second one.
Yeah, this one? This one?
Yeah, which forum now?
Yeah.
Go down. So this is the second slide, right?
Yes. Okay. So first slide, second slide, third one?
Okay. Yeah. Arbitration depends on the forum. I mean,
the provisional,
so the provisional remedies.
Yeah.
So what's the range? I mean, what's the forum? What do you mean by forum?
Okay. So before I get that, you reminded me of something else. Depending on which forum, which dispute resolution forum you've used, your emails will have different value. Let's say you say something without prejudice. Because you're commercial people, you want to negotiate. You mark something without prejudice. We do it all the time.
Yeah, of course.
It's not going to be recognized by the Dubai courts. They'll be like, no. I've had cases where clients have said, okay, you owe me $1 million. I'll take 800,000 if provided you pay me today. They renege on that. They're sued. 3 months, a couple of years later, you get a court judgment, and the court judgment says you get 800,000. And you're like, well, why 800,000? He owes me $1 million. No, but in writing you said, I'll accept 800. So you'll never not run into that problem if you're in arbitration or DIFC courts. So again, practical consequences. So so when I say on the forum, there are two things there. One is the applicable rules. So you get the ICC rules, you get the DISC rules, the ADGM rules. All of those rules will have different provisions regarding what kind of provisional relief you can give. The second consideration is what we call the seat of arbitration, or the legal place of arbitration. Why that is significant is it determines which court has supervisory jurisdiction over an arbitration. So if you're in onshore, if you're, say, under the ICC rules in Dubai or Sharjah, then it is the Dubai courts or the Sharjah courts that have jurisdiction to give urgent relief. And they will use the civil procedure law, which is very limited. But if your seat is the DIFC courts, in addition to going to the tribunal, you can also go to the DIFC courts. And you can, so in any event, you can either go to the tribunal or you can go to the court. If you're in the DIFC courts, you're going to get the worldwide freezing injunctions and all of those anti-suit injunctions and a huge range of remedies. They're difficult to get, but in theory, they're available. So you need to, two things are, one is the set of rules, and that's becoming, I think, less important because the rules are becoming very homogenized. There was a time when there used to be a huge difference between rules. Now things are getting standardized because it's the same community, and the rules are being updated. What really is the kicker is what you put in your contract as the seat or place of arbitration.
Okay, so whether you specify the Dubai local court or DIFC.
Yeah. So if you say so for example, all disputes howsoever arising out of this contract shall be finally resolved by arbitration by 3 arbitrators under the DISC rules. The language of the arbitration shall be English, and the seat of the arbitration shall be DIFC, as opposed to the seat of the arbitration shall be Dubai, or the seat of arbitration shall be Paris. Because the combinations are endless. You can have ICC rules under Indian law seated in Sydney or Canberra. So you need to think about what works best for you.
And then out of the sort of, if we take GCC, I mean, I'm not spreading the region, where should you sort of,
DIFC.
What is better in terms of
DIFC.
DFC?
DIFC or ADGM, I think DIFC is a little bit better because it's a little bit more international in its reach. Because in the region, say a place like Saudi or Qatar, they have their laws, but it's still very difficult to enforce an arbitration award. So
Best place is Saudi or Qatar?
No.
No.
Okay. It's very difficult to do that.
Okay.
So what you would do is you would have, and I have that very frequently. So let's say you have a problem in Iraq. The last thing you want to do is go to the Iraqi courts. The last thing you want to do is have arbitration in Iraq. So the parties agree to arbitration in Dubai or the DIFC. Let's say the DIFC. They get an award in their favor. They have it ratified by the DIFC courts, and then it goes onshore. The moment it goes onshore, we can ask a Dubai judge to send that judgment. Now it's a judgment because it's not an award anymore because it's been ratified. Send it under the Riyadh Convention to his counterpart in Iraq. And then he has to enforce it.
Okay.
Chitra, how about the cost? I mean, in all this, how does the cost impact come in? How much do the courts charge each of these, which economically would be viable?
Yeah, so the cheapest again is the onshore courts. In Dubai, the maximum fee that you'll ever pay is 40,000 dirhams. In Sharjah, Abu Dhabi, and the other Emirates, it's 30,000. The worst place is Ras Al Khaimah because there's no cap on the court fee. So I think it's
Greater
again
than 1 million, there's
Huh?
no cap. Greater than 1 million claim, there's no cap.
correct. Yeah, up to 1 million you're fine. More than that, you're done. That's the court fee. DIFC courts are expensive, but you can get your court fees back, as in the local courts. Arbitration is also expensive. Perhaps the most expensive of the three is arbitration, because you have to pay the arbitration institution, you need to pay your arbitrators. But again, that can be recovered. So it really is a scale. And again, which is why you should think about where you want to go. In arbitration, the parties are supposed to share the costs equally. And it used to be the case that, if I was the claimant and you were the defendant and you refuse to pay, I have to pay, and I have to wait until the end of the case to get it back. No longer the case. If you refuse to pay, I still have to pay, but I can get an immediate order against you requiring you to pay, which I can then enforce. So in practice, it's going to be a shared cost.
Thank you, Chatra.
Yeah.
With this, we move on to the next topic, which is check bounces. Now, check bounces has been, a new law has come in starting January this year, that check bounce is no more a criminal offense. It's been with SMEs for a very long time, and in our bank, we've had so many customers who didn't know what's the process or what would happen in case a check bounces. So in the past, it's been like customers bounced a check and he thought the case is already filed, so he never came back. So he stepped out of the country and there's a check bounce in his account and he didn't come back because he thought there's already a case filed. So perennially it was there that in case a check bounce, there was an option that you could go pay a fine and come out, or you were jailed. So we have had so many big institutions just collapse because one check bounce, and if you have a liability of 25 million in the market and somebody else tells that this bank is bounced a check on, so all the banks go bang, bang, bang. And so this is always a problem with check bounces in this country. So this year, starting Jan 1st, they have decriminalized the check bounce. So Chatra, if you can just add more about that.
Yeah, sure. So that's a law that came into effect on the 2nd of January. So what you see on screen is what used to be the criminal offense. Articles 401, 2, and 3 of the Penal Code. And that has been taken out. Now, what you should bear in mind is that not all check-related offenses have been decriminalized. It's only the act of writing a check that later becomes dishonored because there are sufficient funds. So this, I'm sorry, the text is small, but if you look at this, what remains a criminal offense are actual fraudulent acts. The act of criminalizing a check, to my mind, was a very old-fashioned notion. And I think this was certainly the right step. It's not a criminal matter, unless there was actually a fraud. And that's where the law is right now. Gentlemen, jump in wherever you want to. So now what the law does is really sort of amp up the civil punishments available, or the civil remedies available. And one of the things that I found the most interesting was they can actually name and shame people. The court has the power to do that. In a country where it takes privacy very, very seriously, I thought this was a real signaling of intent that, we still take this as a very serious offense. And they can take away your checkbooks if you're in a commercial context and you're a repeat offender. So there's still a lot of bite left in the law, but the key difference is that you will not immediately be thrown in jail just because your check bounced because there wasn't enough funds. I suppose the real question then is, is it still valuable as security? I mean, that was the biggest utility of a check.
Now if you've given a check to someone and it returns unpaid, so what are the options available? Now, while the decriminalization happened, the law also brought in a small change of filing an execution faster. Now, earlier your option was, once your check bounces, somebody has paid a fine and he's let go. So there is nothing else you could do with the check other than go for a civil action in the local courts. But now we have an option of something which we call, you can directly file an execution. And this execution, correct me if I'm wrong, even if you have a check of someone who's bounced it a decade back, okay, this has been something which is very, very important, that if someone has bounced a check and he's paid a fine and got away, that check can be used now to file a case for execution. So though the law changed and you can't file a case on a bounced check, but now you can take this as an execution. So that's been a good change, that they've decriminalized the check, but now you can use it for a civil issue straight, and it's much more faster. So you can get a travel ban on someone very quickly, eventually you can attach, and finally get an arrest order in the same order. So that helps, though the law is decriminalized, going the civil route will definitely help in case you have someone who owes you money. Or if you owe money to someone and the check is bounced, you must be aware that though the decriminalization has happened, there is this clause in the law.
This is for all Emirates? So it's uniform for all Emirates? Or?
It's available for all Emirates, but Abu Dhabi, I think the cost is a little higher there.
Yeah. So that's spot on, right? But it's not 10 years though.
Sorry?
See, this is the civil steps that you mean for on a bounce check?
Yeah, on the bounce check. So the check bounced. Now you want to recover, and like the travel ban, you filing it.
So in Dubai, it's very, as I'm aware, it's a very simple process. You go to Al Daid and go approach them, and it goes, and in within a period of 1 week, you get a response. It goes to the judge, and in about 14-15 days, you can get a travel ban.
Yeah, we've actually, so the process is set out here.
Can I just, recently also, as per the new law, you can recover partial amount, right?
That's correct.
If the entire amount is not there, the bank returns the instrument saying that the partial amount has been recovered and paid. So whatever is there, it will sweep, but you still have access to the instrument.
Absolutely right. Now, earlier, if the amount was only 100,000, you cut a check for 100,000 and you had only 80,000, because you didn't have 100,000, the check would go unreturned. But now, 80,000 is paid, and
You get the instrument.
yeah, you get the instrument back.
But this is automatic, or we have to ask the bank to take us?
It is automatic.
Before they return the check, they will sweep the entire balance if the balance is insufficient, and then return the check, and there has to be a noting behind the check.
That's right. And it's the bank mandatorily has to offer you to say, look, this amount is there, do you want it or not? It's up to you as the beneficiary to say, I don't want it. I mean, but when are you going to say no? You're going to take whatever value that you can, and then you sue on the balance. So you get that notification. So in the case you do that, you get that confirmation from the bank that a partial amount has been paid, and then you take the check and that notification, it has to be endorsed on the check itself, go to the execution court, get it stamped, and the rest, the balance, will be deemed as a already confirmed judgment. That's what the law says. A check, provided that there's no, it's not forged or anything. If you look at the last point here, it doesn't mean that it's a fait accompli. You can somebody can say, well, no, I never signed this check. So those defenses are still there, but that's going to be after you go through this whole thing. It's actually very, very quick. Yes, sir.
You mentioned about the partial amount being now credited to the beneficiary account, but for the settlement of the remaining amount, when you say it is very quick, how quick it can be, in the sense the legal proceeding to start?
So, see, that's the thing. You don't need a legal proceeding to prove it. Because back in, if you and I were having this conversation this time last year, we'll have to take the check, go to a judge, and convince the judge to give me a judgment in my favor. And then that can be appealed twice. All of that is now out. You go to the judge and say, look, here's a check, here's confirmation that it got bounced, or either for the entire amount or a partial amount. The judge has no choice but to stamp it and say, yes, this is, which is what we call an executive deed. It's capable of self-enforcement. You're given 15 days to settle it, if I was the person who drew the check. If you, as the holder of the check, think that I'm going to run away, at the time you do this, you can ask the court, put a travel ban on me as well. So by the time I get the 15-day notice, my wings are already clipped, I'm here. So you're already at that execution phase now. Whether you'll actually get your money or not, only the good Lord knows, because it really depends on the capability of the person to pay.
But the travel ban can be actually implemented within 2 weeks or 15 days.
The travel ban can be gotten within 2 days.
Okay. Thanks.
And what it further does is it blocks all the other bank accounts of that particular individual or company.
You can apply for that consequentially. So
Sure. Since I have the mic, let me just ask one more follow-up question. This, I know, is conversation about check bouncing, but we live in a world where payments are increasingly becoming digital, right? And I mean, I personally don't use checkbook anymore. But the other mechanism is adding card to the file, right? Credit cards or debit cards, where you're saying that charge this card on 5th of future date. And if the card payment bounces, is this treated similarly? Because there's a promise to pay through a card as an instrument and not check as an instrument.
Yeah.
And there is no funds in the bank.
Yeah. I mean, this is one of the ironies of life, that the only time that you actually are likely to write a check is to your bank. But no. The credit cards are not, this is only applicable to the rather antiquated instrument of a check. You're right, it's old. The law is rarely at the cutting edge of these things. We're always playing a game of catch-up.
Okay.
What was happening is, I mean, people were not taking commercial decisions. They were going ahead with a commercial transaction based on the security of a check. To prevent that and to actually go into the commercials of a transaction and do a transaction after verifying all the facts and check on your client and all that. So people were entering into reckless transactions with the backup of the check. To discourage that, and the courts are being burdened, banks were being burdened. So to discourage that trend, and it has been a long evolutionary process. We have gone through situations where people have come out by paying fine and millions have gone.
and the checks, the criminal cases used to be filed in the police stations. So there was heavy load on the police stations. So yeah, the legal system was, the police were burdened. You had only 2 people doing there, and every bank would have thousands of cases. So then they put a cap and said,
Police used to discourage us, actually.
yeah,
But the other thing is, the check on a personal side, the rental payments are through checks, right? And it is a sort of security deposit, and we know direct debits are coming. There is a push to do away with check payments and just do direct debits to the accounts. So then still the bounce can happen. But will that be now treated in the same law?
but as you said earlier, in the current context, there's no case that you can file on.
On
All I
one
can
side-
say is not yet. Yeah, it's a very good question. The answer is not yet. We may well get there, but the law doesn't sort of, just, it's very specific to checks. It doesn't apply to payment instruments or mechanism across the board.
Thank you.
But Chatra, in your experience, then in the situation like that, what is the remedy now for the landlord to recover the dues if it's an online payment which has bounced? I mean,
It's an ordinary
Civil-
recovery.
civil case.
It's an ordinary
Civil
action.
case that-
Yeah, it's an ordinary civil case. Yeah.
I have a question. Now, regarding the filing for the bounce check, if you want to put a ban on travel, do you do it through the police, the Attorney General office, or the court? How? Okay, if you want to put a ban on somebody for either bouncing check or, let us say, for criminal activities that you are filing a case against, how you do it?
There's a center called Al Daid, correct me if I'm wrong. You approach them, and then the process starts.
Where is
So
this? Would you know?
if you just Google, you'll find a lot of centers.
Sorry, what's called?
Al Daid.
But they don't really give the order itself. But they're the first
Yeah,
step.
that's the first step. So for you, if you want to file a case against someone, and you have an instrument in hand, that's the place you go, and then you start.
Like the Ahmed centers? Or?
Yeah, it's similar to Ahmed centers. So every institution, for example, a bank does a different route, but for the general public, is either through a lawyer or through Al Daid.
So if you want to get a travel ban, there are two ways. I mean, one is the police or the public prosecutor. The other is the civil courts. So if you are trying to prevent somebody who has committed a crime and is trying to leave, you go to the police or the prosecutor, and they give that order there. But bear in mind, if you have a bounce check, the police will not accept it anymore because it's not a crime. For that, you need to go to the civil court. So the civil court, there are a number of things. One, if you have a bounce check and you think this guy is going to run away, you go to the center, you get that stamping done, and then you go to the execution court. And when you are asking the execution court to execute this, you say, by the way, I think this guy is going to go away. Can you put a travel ban on him? Now, you can still get a travel ban even if you don't have any of this. For example, say it's a guarantor, a personal guarantor of a check, right? No assets here, no permanent place of residence, everything is gone down. You can still go to an urgent affairs judge and say, look, he's personally guaranteed this loan to me as a principal obligor. I am worried that he will fly away. Put a travel ban on him, and the court will do that. So it really depends on the circumstances. Is it criminal? Is it a bounce check? Is it an ordinary civil matter? Is it a commercial matter? All those things can be done. Yes, sir.
Hi, good evening. I have a question. Let's say that the check is issued by the company, right? So it get bounced, the company bankrupt. So who will be the liable for that bounce check? Is it the founders, the owners? Who? It's named under LLC, right?
The signatory.
No. So there is some confusion about this, especially when it came to the criminal aspect of it. If a company check bounces, it is the company's debt, right? It used to be the case that the signatory was criminally liable for actually signing the check that bounced, but it's the company that was liable for the amount. I've also seen some cases, and again, this is because it's a civil law system, there's no system of binding precedent, where the court said, in fact, the person who signed the check on behalf of the company also takes on liability. And we've used that to our advantage, although I don't think that's quite correct. What you are there is an agent of the company, or you're an authorized signatory. So the prudent view, I think the correct view is that if a company has written a check which bounces, then that's the company's debt and nobody else's. But there have been a couple of cases where a court have said, it's not just the company, it's also the person who signed it.
Because he's given a personal guarantor, if in the
that kind of
application
thinking,
form he's
yeah.
signed as a personal guarantor, then he's fully liable.
So to your question, majority of the cases, if you have to file a case against someone, it will be against a signatory.
And if they are joint signatories, it will be available on both.
Strategically
file
also,
both.
that's what you want. A company is non-existent, right? It only exists in imagination. People are real. You put pressure on people, they're more likely to cave.
And company also, especially in limited liability, the capital can be relatively small. access to the company capital might not be enough to pay the transaction.
Yeah, yeah, yeah. I mean, the capital is very negligible.
You can win the case, but you may never recover the money.
Yes, sir.
So I think thanks for all the legal perspective. From a perspective, practical and business owner perspective, right? There's a dispute, the check has bounced. There's a cost of litigation, there is a time effort which goes in recovering. How do you balance between whether this is a case when a dispute was proceeding or not? Should I write off? Should I still go and bear the cost of litigation? Or should I just try to settle?
It depends
Okay.
upon who's given you the check
Yeah.
and what is his credit worthiness. So it's always better, as he said earlier, in case you have an option of settling it, take it. Correct me, Chandran.
Absolutely. I mean, the golden rule is don't throw good money after bad.
Yeah.
Settling is when I know the person is in the country. So let's say if there's a 5,000 dirham, as an example, right, a claim. Should I actually go through all of this for a 5,000 dirham or 10,000 dirham dispute on the check, or just live with it?
That's a deeply personal decision. Yeah. It's very high, and also again, I mean, if it's something like this, I mean, if you have a check, you can do it yourself. Honestly, it's not for whatever it's worth. You can do it yourself.
Especially in Dubai.
Yeah,
The cost
very
is
easy,
quite
very
relatively
easy.
low.
But if it's anything a little bit more complex than that, where you actually need to spend time, because you have a bounce check, it's a bounce check, you have the instrument. But if that is not there, if it's a contractual breach, you have to make that decision, and it's always a commercial one. And one of the things that you try to find out is, again, it's tricky when it's low or mid-level. High value ones, you can always justify that decision. But again, you go to Dubai courts, let's say it's a 50,000 dirham claim, you've paid your lawyers 30,000, so even if you win, you're only going to get 20 back. Which is again important. Why is it important to go to the right forum? Whether you should, it's a case-by-case decision. I always tell clients, I've frequently told clients, just don't waste your money. I mean,
Even as a bank, this question comes up when you have a bad case, whether we actually follow the legal route or we just take a provision and move on.
yeah.
So, absolutely, it depends on
all
the
depends
probability
upon-
of your recovery.
Yeah, it all depends upon the probability to collect.
If there's a lock in a small business, all that we find is a lock on the warehouse, and it,
Personal lending side, right, on a credit card default, you say 5,000 dirham default, should I just write off the NPA or pursue this case to
Yeah,
recover 5,000?
you know what they say. If you owe the bank 1,000 dirhams, you have a problem. If you owe the bank 1,000,000 dirhams, the bank has a problem.
but if you owe the bank, you know for sure that there'll be some kind of a consequence going forward. So it's always better to keep it clean. Come to a negotiated settlement and just get your records clean.
Yeah. Now,
It takes
especially
time, but
ACB.
it just crawls up. There was a very interesting article I read about an Englishman transit. I mean, the flight was not even supposed to land here. It was an emergency landing, and they had to come in, and after 14 years, he was taken into custody here. So try to keep the record clean. Have a negotiated settlement, but get your certificate of clearance.
So if you make settlement with the bank, they will not issue travel ban to you?
If a bank has given you a settlement, it's a contract. There will not be a travel ban.
That's it.
If it's a settlement.
If
Sorry,
you've
Sunil.
paid, if you've paid as per the settlement terms, you have settled. So there's no outstanding pending. You owe nothing to the bank. So the bank will not file any
Taken a
further
hit.
cases.
The bank has taken a hit, and the bank has written off an amount. But if you clear, it's clear.
So if you hold a settlement letter, they would.
Is there a chance that the bank file you travel ban without your knowledge?
Yes. Always, yeah. you don't signal that.
No, that's not always. But yeah, it is. So every time we're going to file a case, we'll definitely notify you. Now that would be on your SMS, as an SMS on your mobile. And definitely, I mean, filing a case for a bank is the last option. It is, I mean, in my entire experience, I wouldn't want to file a case on anyone. I would want the customer to be out and service the debt. If I put him in jail or I enter into a difficulty with him, I'm not going to collect. So filing a case will be a very last option for the bank.
Just if the person is out of the country, what are your options? First question. And second question is impact on the credit report now.
Yeah, the credit report, I think that this gentleman can answer. Yeah.
See, credit report is based on, for example, I don't think that a personal check that you've given to someone makes any impact on your credit history. But if it is a bank, of course, if you've made one payment default, it impacts. So everything is recorded. If you ask for an ACB report, it'll clearly show how many days you've not paid your dues.
Even your Etisalat bills are recorded. Delays there.
Yeah, so every delay is recorded. So it does make an impact to a bank. So it deeply impacts if you've missed payments, your entire credit history is at stake. There's a cost attached to it. So Etisalat, they wouldn't want to, if your bill is for 2,000 and the cost for filing is 5,000, I don't think they will file.
Technically, yes, they can. And to your question, sir, on if the client is abroad and negotiating from outside, we are going through a live case now where 3 banks are involved. We've actually removed the travel ban in negotiation with all the 3 banks, given him a confirmation and have asked him to come and try to sit across the table and settle. So even if there's a travel ban and he has gone out and the banks have put a travel ban, we can withdraw the travel ban, the
Absolutely, we can work
legalities
out a
of it,
settlement
we will explain.
even if the
Yeah.
customer is outside the country.
And people have come in, and we are actually in the midst of a settlement where the gentleman was in England. He has come in, and we should be going in for negotiated settlement.
Even if the cause of the default is for example, a credit card rather than a normal bounce check, is it the same?
Yeah, you can still get a travel ban. It's difficult. It's more difficult to get, but in theory you can.
I'll just, give a layman's perspective here. Behind every credit card, there is a check which has been given to the bank at the time of issuance of the credit card. The bank still holds that check as an instrument of security.
No, absolutely right.
About continuing the question what he asked, but what if the company is bankrupt and filed for bankruptcy, then what do you do?
When you say you, who do you mean?
The check is bounced and then the company is filed for bankruptcy. Then what do you
Then what you do is normally when banks extend a facility or a loan or any kind of other transaction they enter into, the banks insist on a personal guarantee of the signatory or any of the shareholders. So the other remedy that is available to the banks is to then go after the personal assets of those individuals. If there is nothing
bank's
there,
perspective, yes. Suppose a company has given me a check,
Okay.
and that check is bounced, and he says, "Yeah, we'll pay, I'll pay," and then 3 weeks later, I find that the guy is actually filed for bankruptcy. Then what do you do?
Then you
it's a
need
part
to. So under the bankruptcy procedures, one of the things that happens is once the court appoints a trustee in bankruptcy, the trustee will publish advertisements asking for creditors to put in their claims. You'll need to put in your claim. There's a very small window of time that you can do it. You do that, then it's up to the trustee to see whether he will accept it or reject it. If he accepts it, which should happen if you have a legitimate claim, then you essentially are in line to get a pro rata share. You'll get pennies on the dollar, but it's just hard luck at that point. Yeah. So
same.
the bank is actually, unless you're a secured creditor. If you're a secured creditor, yes, you have certain assets that are earmarked for you. And you've got to be very careful that, you've registered them and everything has been perfected.
TR and all that. But again, the cost of a recovery vis-a-vis the amount you recover, it doesn't make sense for us.
So something that we do, especially in where we have cases in Ras Al Khaimah, to get over the court fee problem is to actually start bankruptcy proceedings, because the threshold for starting a creditor-led bankruptcy is very, very low.
And especially of late, bankruptcy cases have significantly gone up for us as well.
Oh, yeah.
And 3 years back, we didn't even have a great law here.
The law is new. I mean, the law is new. The judges are just about getting their head around it. And the experts are just about getting their head around it. We've had some ridiculous decisions over the last couple of years, but you're getting there. I mean, there was a phase of time where the courts were increasingly favoring restructuring as opposed to bankruptcy. I think there was a policy directive to say, we can't have a whole heap of companies go into bankruptcy. We need to try and sort of protect them, revive them, which is the whole point of a bankruptcy. Bankruptcy used to be a dirty word here, right? It used to be a criminal offense. Bankruptcy is actually a protection mechanism, and it's finally being seen in that way. So you'll get something out of it, but unfortunately, again, once the horse is dead, you can't really sort of get any more mileage out of it.
So this guy, this company filed bankruptcy, he's a bit protected.
It's not protected in that sense. It's recognition that companies sometimes fail. Restructuring is there to help to have a system in place where somebody steps in and tries to revive the company, comes to a deal with all its creditors and say, look, listen, we can't pay you now. If we try to pay you now, you're not going to get anything. But we still have a plan. We've still managed to get some money. We need you to come to a kind of moratorium or some agreement saying that you'll just call your lawyers off, give us, this is our plan, we'll keep you informed, and they actually try to resuscitate it so that you don't get your money today, but you might get it in five years' time.
We have many cases here in Abu Dhabi.
Yeah, absolutely. Absolutely. It's a good
restructuring is always a good approach because it gives you an option to repay in small amounts or whatever the terms that you've agreed with. As I said earlier, there's so many cases in the past where people were not given an opportunity and they couldn't before. At one point of time, I have a liability with 5 banks. I'm talking to one, and the other 4 have filed already a case. So then everything comes to a halt. So going the restructuring option through a court, now you can agree and say that at least you're not in jail. You will say, I'll work out a settlement with you.
And if an organization, if a company continue to work, imagine NMC just to say, it just closed down, tens of thousands of people, and so family without.
Absolutely, that
There
was
you have
the
it.
main purpose.
Yeah, absolutely.
Keep it alive, they work, and also as long as it's not back.
The stigma of a jail term was really impacting people, and we have seen in the previous cycles in 2009, 15, post-COVID little less, but businesses getting destroyed for the fear of a jail term. It was pretty ridiculous actually.
Also, in my opinion, we should also look to what business you're talking to, the business model. Because if you are in front of, let me say, NMC, you see that the business is healthy, so you should provide oxygen. But if you are, let's say, a Braj, you know it is unhealthy, then you have to remove the plug immediately. So you have to see what is the case before. You should not come to the same conclusion with different questions. So
You're absolutely right. And this is why in most developed countries, bankruptcy is a specialist court. They're not the guys who listen who hear your traffic offenses. They have specialist judges, specialist trustees who actually have that acumen to see, is this company is it realistic to try and keep this alive? Can it, or do we pull the plug?
you should be almost a businessman also, not only a pure
Absolutely,
administrator.
yeah.
And I can tell you, I'm Italian. I had a case 25 years ago. Very interesting, because when there is a bankruptcy filed in court, and generally in Italy 3 judges are appointed by the state, but the work is very complex because suppose the person with power of attorney just before bankruptcy it transferred $50 million to a certain supplier, no? Then there is a law that you get back this amount, because why you pay that supplier and not the other supplier? Is your friend? And then everything come back into the pot, and then there is clear priority to who to pay. First, the tax to the government. Second, the employees. Third, the supplier with a proportionate, so because you cannot pay all, so maybe, but pro rata, and so on and so on. Very complex.
Yeah, so even under the law here, there's a 3-year look-back period. So once the trustee is appointed, he gets to look back for 3 years. In common law jurisdictions, it's a little bit more developed because it's 3 years, but if it's, say, a fraudulent transfer, then you can look even further. So you can have a related party transaction, or you make a preference. Right? It may not be somebody you like, somebody you're related to, or it might not be fraudulent, but it says, you know, I like LM better than Sunil, so I'm going to pay him. So those can be done. And then you say, and you're right, I mean, there's a clear waterfall, but right at the top of that waterfall is usually the trustee. Because again, that's recognition that they're actually doing some very difficult work.
Okay, yes, I was starting with government, but in fact, because they are paid,
Yeah.
for sure, you're right.
So which one comes first? Is it the bankruptcy comes first or restructuring comes first?
So let's say so there's 2 types. One is a voluntary bankruptcy, where you say, okay, you've thrown in the towel. The other is a creditor-led bankruptcy. So if you are owed more than 100,000 dirhams in debt, you've given a written notice to pay, and you have not been paid in 30 days, 30 working days is what the law says, you are automatically entitled to file that application. But the court will then look at that application and they'll appoint an expert. And that expert will be asked to look in to see whether this company should be actually placed in bankruptcy or whether there's a chance of restructuring it. And it's ultimately up to the court. The court will say, I think this company can survive. So it could start off with a bankruptcy application, but what could happen is actually a restructuring. So I may want to put this company 6 feet under. And remember, egos matter. Sometimes you are so aggrieved at the other chap, you know, it's literally, I'm going to burn you. I don't care what it takes. I don't care what it costs. I will burn you. And it's a common sentiment. And they start off with that, but it may be restructuring.
From a banking perspective, I'll take a question. From a banking perspective, you can have restructuring. I mean, bankruptcy did not come into play also. Again, before going into any legalities, we will try our best to have a negotiated settlement, extend terms, give more of a moratorium to tide over cash flows. So we are also seeing a change in approach.
Yeah, in case it's anytime you feel your cash flows down and you owe money to the banks, it's better to go to the banks and negotiate. And
we're
most of the
actually
banks
seeing a complete change in approach in the banks. And I can talk from an insider's perspective, from a business perspective. Sunil comes in with a collection perspective. We are more than ready to support businesses, and that is what the whole COVID experience taught us, with the government support in terms of allowing businesses to stay afloat and come out of the tunnel. We can really see there's a change in approach in the banks also. If there's a genuine problem, and if you're not hiding stuff, and if you're able to put down your problems and able to explain it to the guy across the table, chances are that in the majority of the cases, we are restructuring and giving simpler, easier terms with a moratorium thrown in so that the cash flow, the business is able to recover and meet the cash flow requirements for repayments.
all you have to show is the intent, and the banks are accommodating all the time. COVID is a perfect example. I mean,
Is it all banks or just you guys?
Because we
the
represent,
SME bank.
because we represent a huge chunk of the SME segment, and this is a common problem. Even where one trade can actually knock off a company. So that is, yeah, absolutely.
True.
That actually starts the chain reaction. Suppose you don't get paid, you cannot pay me. Right.
So
And someone on
that-
top goes away, the entire chain is completely stressed. So, yes, very true. That's always a challenge.
just I want to ask a question. I know it's outside this general discussion. I want just to compare with Saudi Arabia, the bankruptcy law. Are they, okay, I worked on both. Now, I think there is similarities, but also there are differences. Now, for example, when you declare bankruptcy there under the, I think, Chapter 14 of the Saudi law, is that you have to go to the court, you have to submit the documents, you have to submit a statement of account, you have to show how much you owe, how much you may collect, whatever it is, go to the judge, and the judge will accept it or not. If he accepts it, he will appoint after that the what's called the trustee. He will appoint the trustee, and then the process will start in really putting the financial plan through a third party, which should be one of the largest, let us say, one of a financial house or whatever. Okay, they put the plan go for voting to the different parties, the banks, the creditors, the employees, everyone. And then, based on the result, go back to the judge to issue the judgment at the end, where after that the plan implementation will start. Could be 5, 10 years. The case I was on was about 13 years to pay the money. So I just, I know it's outside, but I want to know, is it similar in UAE like in Saudi Arabia?
I think that the new regime is a lot more streamlined, where you get difficulty is at the trustee stage trying to collect assets, but that's generally in a creditor-led environment. If it's a company-led insolvency, then I think what you described is true, and it's unless there are creditors who come in and object, and they really don't have much grounds to object. All they can say is, okay, well, we want to be paid out. And it may well be like, okay, fine. If you're secured, great. If you're not secured, you'll get a pro rata payment. But I'm not sufficiently familiar with the Saudi regime to...
Hi. About the you go to the court, and I feel an unfair judgment passed against me because so they appointed an expert who had no idea what was happening, and the judge took that expert's opinion and then went away. So how do you go back and claim what you feel that you should have got that money? How do you do that?
Depends on where you are in the process. You have the option of appealing it. Sometimes you're too late in the process to file an appeal. There are very limited grounds to file for a review of a judgment, but those are largely based on either you can have to prove that a fraud occurred or that there was some serious error of law. Whatever the expert comes up is seen as a question of fact. And you can only argue matters of fact between the first two courts, Court of First Instance and Court of Appeal. Once you get to the Court of Cassation, facts are completely out. It is a flaw in the system.
And as
it's
you
a
said rightly,
significant flaw.
Yeah. And as you said rightly, experts here the way they give out, they're not, that's always a little, difficult to get a good expert.
There are some there's some good experts, but there are also some pretty awful experts. And it's all picked at random. One of the things that you can do to minimize it is sometimes engage your own expert. And before the court appoints an expert, you give that report in. So at least you create doubt in the experts, in the court's mind as to, okay, well, look, there's one expert. And we do that fairly frequently when it comes to high value claims. We already go to somebody, it's not just an expert we know is good, who's credible, who's accredited with the courts. We give him all the information, he comes up with a report. And when we are filing our statement of claim, we submit it with it. Now, in fact, you're supposed to do that in certain types of claim. So for example, in a trademark claim or a construction matter, you're supposed to go to court with an expert report in hand. Now, the court still appoints its own experts. Another thing that you can do is, at least in Dubai, you can ask the court to appoint somebody from the ruler's court. The ruler's court has a number of experts, but you can't always get them. It's an entirely discretionary thing. They're actually quite good. They're incorruptible. They're actually proper experts who take their time to understand what's going on, but you're not going to get that most of the time. And I'm sorry to say, I've seen cases of rampant corruption. And it is a huge flaw in the system. I had about 12 years ago, it was actually a friend of mine, Emirati chap, very smart, Ivy League educated, was working in the Justice Ministry. He did a survey of the number of judgments that are based or blindly based on experts' reports, as opposed to what had independent judicial thinking. He came out with a report to say, well, let's just get rid of the judges. Why do we need judges? They're all saying what the experts say anyway. Let's just leave it to expert adjudication. He was very kindly told, don't do this kind of thing again, and he was transferred to a different department. But it's a problem. I'm sorry to hear that, but unfortunately I've seen my fair share of that. There are plenty of cases in the UAE, at onshore UAE, which I've won, which I had no business winning, and I've lost and had no business losing.
We lost just because the expert. It's an engineering matter. An accounting guy comes and says, no, that's how it is. So
You get complete U-turn judgments from experts. We have all faced it.
Yeah.
just
I have a query for the banks. If a company comes for restructuring, would you consider this as option, like taking over the defaulter company by a financially very good company so that they can pay over the debts? And if yes, what is the process you all follow to choose which company to select to who will take over the defaulter company?
No, if it is two companies, if I read your question right,
There is a defaulter company.
Yes.
They are unable to pay the debts. So
Okay.
you are thinking of a restructuring option.
okay,
One of the consideration of the restructuring option is taking over the defaulter company by another company who is financially very good, so
Okay.
that they can finally pay off the debts to you.
sure.
And if you do consider this option, then what is the process you follow to select this company who will take over the defaulter company?
That should come from the company. The other company should be able
It
to...
doesn't fall under the bank's ambit.
Yeah, the other company should be willing to take yours, and both of you come to the bank, and then
Okay.
so then I will review and say, yeah, he's financially sound, and then I would say, okay, if he's willing to take and his repayment ability shows clearly, demonstrates that he can pay the additional installment amount, I'll definitely consider it.
The loan doesn't move to the new company till such time both of them have actually entered into an agreement of a takeover or fulfilled the contractual terms of a takeover. It is not within the bank's ambit to advise clients for a takeover. Yes, if there is synergy, if there is a commercial interest and commercial synergy with both the entities being taken over or one company acquiring the other, they can do it, but not banks.
The bank
normally
will
don't
not
get
choose
involved.
any
Yeah.
company.
Yeah.
The bank,
Yeah.
okay. No, no,
Those are for very big companies where it is in the interest of the bank to actually find a buyer. But here we're talking of in the SME space and all, we don't do that.
that's why one of these instances where the bank only selected someone, so I was thinking whether the same thing is followed here with the Swiss
They cannot
challenge
force it
bid
down. They cannot force it down. If there is a synergy, if there's a commercial interest of the acquiring entity,
It is
and he
po-
sees, the entity sees value, it is their prerogative. We cannot force it down.
Outside the bank's ambit, there could be a consultant who would say, there's an X company, would you be interested? So all this is outside the bank's ambit. But yeah, if it is a restructure being done by the bank, and if there's one leading debtor who's willing to take over the rest, that could be possible, worked, but outside the bank's ambit.
Practice can be done, can be explored, but banks will not enter that domain.
In respect of time, we'll take that as the last question.
There is one person owes me money, which me 1,000 objects. And he already left the country, but the guarantor is still here. How can I recover it, that money?
So it depends on the agreement. It really depends on the agreement that you have. To the what extent has somebody else guaranteed the repayment, and on what terms?
Also, if the guarantor, did he sign the check? That makes a lot of difference. So a guarantor is, if he's given a check, you're filing an execution based on this check, and he's not signed the check, can he file a case? I don't think he can file a case.
He doesn't know. No.
It would be a civil case. You need to go for a civil. Yeah, you will take it to the civil court, and you will not use the
Recovery is,
execution.
in all cases, a civil matter. If you want to recover money, it has to be a civil case.
But who will I file against, the guarantor or the beneficiary?
It depends. It depends, because certain agreements require you to first pursue the principal debtor before you go after the guarantor. In most sort of sophisticated arrangements, the guarantor takes on a principal obligation without the debtor having to sue.
Guarantor give a letter, email that she's the guarantor for this.
Then you'll have to sue on that document.
Yeah, not based on the check.
So the guarantor, I will file case for the guarantor.
Well,
It would be a civil matter.
it'll be a civil matter.
It's-
Whether you can do it or not,
There's
you'll have to
no
look at
use of the check here.
In theory, yes. If somebody is guaranteed.
Whether the court accepts it, you have to explore that, maybe with a lawyer. Thank you.
Thank you very much.
Thank you very much.
Thank you, everybody.